application is before court and it has not been determined, although it has not expressly been stated granted or not granted, but once it is pending, we don't do anything to prejudice the outcome of the application. So we say that invariably, indirectly, it is still restraining any party from doing anything contrary to the demands of the application. They can't do it so far as this matter is pending, otherwise it will amount to contempt of court, to the best of our understanding of the law. When the court speaks about an early trial, in effect what it means is that it will speed up the process towards the determination of the matter, so that this whole issue of injunction before final determination will no longer take a center stage. As an officer of the court, I am not in the least in the position to dictate the timetable of the court. But the farthest I can say is that pleadings have not closed in the matter, as you might have rightly heard from the Attorney General. They are yet to file their response. I believe counsel for the first defendant is also yet to file. So until those processes are filed, nobody can tell when we will be giving date for our next appearance.
The point is that the country ought to know that we're a country governed by a constitution that prevails over everyone. We're all under the constitution and laws of Ghana, and therefore the actions of every person must be determined within the premises of the law. Same as a person can even question my constitutional right to prosecute in this country. I've seen that many times. Citizens of the country even file applications. The Supreme Court questioning the Attorney General's power to enter non-prosecution in a certain matter and that kind of thing, and it comes up for determination of the Supreme Court. It's the same way that a decision or an action taken by Parliament can be questioned by citizens of the country. And so, for me, the questions are raised during the hearing of the application for interlocutory injunction, where ones that, for me, have not been determined in this country, and today it has not been determined. It's the very first time that a private member's bill or issues regarding private members' bill are coming up for determination. But private members' bill are quite novel. It occurred only at the time of the former parliament, the 7th parliament, headed by Speaker Professor Michael Quay. It was in his time. Of course, it was with my help as Deputy Attorney General that we all sat down, we had a roundtable conference, and then we sat down to craft ways of empowering Parliament to engender or produce its own bills. And it was at the time of the last Parliament headed by Professor Quay that the first private members' bill was passed. And really was without controversy because it did not have any implications for the taxpayer. Now, there are a lot of bills being changed through Parliament now on account of private members, which really have implications for the public purse. And I think for me, as the Attorney General of the Republic, it's a question of important consideration that the court ought to really consider. Because since 1957, as I indicated to the court, since 1957, every constitution the country has had, apart from the 1961, has had provisions on Article 108, which is akin to Article 108 in it. And there has not been any case at all found questioning the circumstances, the ambit, or the extent to which a person can commence a bill which has a case of a taxpayer, but which do not go through the requirements of Article 108. So I think the court ought to consider such a question.